All right, so any questions about what we covered so far? So far we've done mutual assent, which is offer or acceptance, consideration and its exceptions and equity, and now we're moving on to the Statute of Frauds. So any questions before we start our new lesson on the Statute of Frauds? All right, so let's get moving, and the first thing to know is, what is the Statute of Frauds? The Statute of Frauds is sometimes referred to as a rule of evidence. I think that's confusing. You'll learn about evidence with Professor Moriarty, but the rules of evidence say what you can and cannot bring into a court, what courts will and will not hear. We will study in a very important and related rule of evidence called the parole evidence rule next semester when we talk about construction of contracts. The Statute of Frauds is not really a rule of evidence. It's a rule that requires the creation of evidence. And there are reasons why we'd want to have certain types of contracts evidenced by assigned writings. This is actually a very old idea, that we should have evidence of certain types of agreements. It comes back to the English Act for the Prevention of Frauds and Perjuries of 1677. And King Charles II saith, "For prevention of many fraudulent practices, which are commonly endeavored to be upheld by perjury and subordination of perjury, be it enacted this 40th day of June, which shall be in the year of our Lord 1677." And now we actually will see in a minute that this Statute of Frauds is very much mirrored with the one we have today. What are the categories that are required? Leases, estates, interests of freehold, or terms of years, not put into writing and signed by parties so making, shall have the force and effect of leases or estates at will only, and shall not either in law or equity be deemed or taken to have any other greater force or effect. So this statute actually is very similar to the one we have today. This is where it began. So why did this statute come to be? There are three main purposes. We'll see how those purposes come about. One, as we discussed, is evidence. It seems that the wisdom of King Charles has persisted to this day, that at least in those 5 categories, and now we'll add to that sale of goods for more than $500, we want to have evidence of certain types of transactions. You read a case, Jeff Cole Quarries, where an oral agreement was very hard to understand. The parties got into a lot of trouble because they didn't have evidence of what they agreed on. It also has a cautioning function. Before you sign something, do you feel a little bit of trepidation maybe? Has anyone here, for example, signed a car loan or something like that? Right, that last minute before you signed it, did you maybe think twice? Was there some hesitation as you're holding that pen? It becomes real when that ink goes on the paper. And so it cautions you, reminds you of the importance of that document. Notarizing has that same function, right, Mary Beth? Yeah, so when you notarize something and there's the formality, do you find that people take it more seriously?
Yeah, they get their license out and
yeah, they're shaking a little bit, right?
Am I okay?
Am I okay? And you put the seal on it, and then now you have this paper which has now somehow been elevated to a higher status. It provides this caution when you have these requirements. And we also then have a certain type of form. We know that we have assigned writing which must have certain features to it, and so we have some consistency in the law which can help to make transactions more easy to understand and easy to enforce. Now, one question at the forefront here. So I mentioned that this rule comes from 1677. Today is 2017. Does this make sense anymore? Is this a good rule? Does the Statute of Frauds actually fulfill its purpose? We're going to try to answer that question. We're going to learn what it is today, and tomorrow will be a little bit of an investigation into whether or not the statute actually achieves its purpose. Interestingly, the British Parliament, who, by the way, passed that first statute, repealed it, in the most part, in 1954. So, kind of interesting fact, and one that may color your view about whether or not this is a good rule or not, is that the country that originated this rule has mostly gotten rid of it, whereas we have held on to it. It's kind of like the inches system. I mean, it's called the English system of weights and measures, and they're on metric, meaning, meanwhile, we're trying to figure out how many, ounces are in a gallon. And so here is one example where the country that originated it has moved past it. Now, they repealed it because they said it actually promotes more fraud than it prevents, and its operation is often lopsided and partial. So as we look at the Statute of Frauds, if we look at the problems and the illustrations in the black letter law, I hope to consistently push you and remind you to think about whether or not it's fulfilling its purpose of preventing fraud, or whether it's actually creating opportunities for fraudulent behavior. Of course, you still need to know what the rule is. And so, what is the rule? Well, the restatement talks about it a little bit. It says that the rule is one that is meant to create evidence, to require reliable existence of evidence, and the terms, so to prevent enforcement and not permit fraud on contracts. So we have that first primary purpose, and Pennsylvania, in particular you may be interested in, seems to be going away from the restatement. The restatement is kind of cleaving to the idea that it is so very important to have. Pennsylvania seems to be getting rid of it in several cases. The Superior Court in 1993, in a case called Horniak v. Sell, said that Pennsylvania does not require contracts that cannot be performed within 1 year to be in writing. And the most recent Pennsylvania case to enforce an oral premarital agreement dates back to 1900. So it does seem that this is an outdated, highly criticized, potentially obstructing of justice type of doctrine. So why would we study such a thing? That's crazy, right? Well, you obviously haven't been in law school long enough to realize that we study lots of old and outdated doctrines here, but there is a purpose. One purpose is, quite frankly, it's going to be on the bar exam, and they love to test on the 1-year exception. The 1-year exception is tricky. I've put in a lot of additional slides to help you understand the 1-year exception because it tends to be something that gets tested on the bar. And in addition, courts like to talk about it. Courts are not entirely consistent. And finally, I'm hoping that by showing you this rule, which might be outdated, you might think for yourselves not just what the law is, but what the law should be. Okay, fine. How do I do it? How do I actually put this doctrine into practice? I will prescribe a simple, relatively simple 3-step method for analyzing any statute of frauds problem. And whenever you're presented with a contract, you should ask these questions. Does this type of contract fall within the statute of frauds? We have 6 categories. If we're not within one of those 6 categories, we don't have to worry about it. So we first see if we're within the statute of frauds, and then we try to get out of it again. If we are within the statute of frauds in a broad way, we look for exceptions. Picture Swiss cheese, right? You're on the cheese, but you're in the area of the cheese, you're trying to find a way out through the hole, trying to get that exception. If you can't get out, if you're stuck with the cheese, then you need to satisfy it, right? How do you satisfy the statute of frauds? You need to have a certain type of signed writing. So that's the 3-step process. And again, to put it in a slightly different way, for those who are, would like a different presentation of that, first you ask if the law requires a writing. And then you see if there's an exemption, meaning the law doesn't really require writing. So you might even think of this as step 1A and 1B if you prefer. Make it a 2-step process. Do you have to have a writing? Well, that depends on if the law requires it and if there's an exemption. And if it does, is the writing satisfactory? Is it satisfactorily signed? Now, courts won't actually, if you are in fact within the statute of frauds, meaning you require signed writing and there's no exception to it, if it's not satisfied, courts will not review the contract on its merits. The effect is to then preclude the enforcement of that contract. And so, if you want a visual example, the statute of frauds you can think of as a Snickers bar, right? When you need it, it's all about satisfaction. So we're going to try to see if we need to satisfy the statute of frauds. So how do we invoke it? Usually this is an affirmative defense, and Professor Heppner has talked to you about affirmative defenses from Federal Rule of Civil Procedure, Section 8C. Right? So you would raise these in general at the pleading stage. When you get a complaint, you then can either answer that complaint or raise defenses. You would then plead a defense called the statute of frauds. You would invoke it by moving. The responding party, the defendant in this case, would say the statute of frauds applies to this contract. And so we kind of use our legal magic to invoke the statute of frauds to dismiss the complaint. Shazam! It's gone. You only have to prove that the statute of frauds is required, there's no exemption, and it's not satisfied, and poof, the statute disappears. The contract disappears. The court will not review it on its merits. So that means the defendant has some work to do. The defendant will bear the burden of proof for this. It's an affirmative defense, and so the defendant makes the argument. Now, I've suggested on an exam for this class, you might present the defendant's argument first in general when doing your analysis. The defendant might say that there is no offer because, right, and go into the analysis, stating facts and making analogies. Here, even more clearly, the defendant will say that the contract is not enforceable because it requires a signed writing and none exists. The defendant has to make that, has to prove that. The plaintiff then shows that the contract is exempt or satisfies it. And if the plaintiff can't accomplish that, then the contract will be dismissed. What does dismissal mean? Remember, that means that the judge will not hear the case on its merits. It will not take testimony. It will not hear depositions. Game over. And for this reason, just in terms of your edification on jurisprudence, courts are a little reluctant to throw out contracts so early. And we'll see that in our Jeff Cole case. So that's the basics. Any questions so far on sort of just the basics of what the Statute of Frauds is? Our next step is going to be, how then does this work in practice? So we know that we have a statute on the books that says certain types of documents require a signed writing. What are those documents? It does vary state to state. We're in a restatement jurisdiction here in this classroom, so you can be prepared to practice in many jurisdictions and to get the answers right on the multi-state bar exam. The contracts that are covered are executor-administrator contracts, suretyship, marriage, land, and a one-year provisions and sales of goods for more than 1 year. And this is commonly abbreviated, in case you need a mnemonic device, as MYLEGS. So this is the order presented in the restatement, but it's usually reordered into MYLEGS as a mnemonic device. We're going to go into detail on what all of these things mean, but for now, you want to be able to spot these as issue spotters, and that acronym may help you to remember it. MYLEGS stands for marriage, contracts made upon consideration thereof. Year, contract not performed within one. Land, for sale of. Executor, who answers for a decedent's duty. Goods, worth more than $5,000. Oh, and by the way, what is a good? You remember what a good is? Yes. Movable and identifiable at the time of contract. So one example of a good in our case coming up will be rocks or asphalt, right? Barrels of salt. Could be something much larger. It could be Boeing aircraft. They generally cost more than $500. And finally, surety, which is answering for another's duty, similar to the executor, but the executor is answering for a decedent's estate, whereas a surety is without the decedent. And in all of these cases, what can we say? What is similar about all of these? Why would these be in a category other than that in ye olde England, King Charles II thought so? What are the purposes of this statute? The purposes are that these are statutes that we want to have additional evidence, that we want to make sure we create evidence. These are statutes, these are contracts that we want to have caution about. These are statutes that we might want to have forms about. I mean, Mary Beth, yeah.
I'm thinking they're pretty important. I mean, some of these things are the kind of things that you would notarize because they're of such importance.
Excellent, right? There are things that we would even maybe require a notary because they are so important. Contracts made in consideration of marriage. Marriage is important, right? And agreeing to provide a dowry or a settlement on a marriage contract can be considered quite important. Contracts that take longer than a year to perform. One issue there might be that they're easy to forget. By the time a year is up, memories are stale. Performance can't be rendered within a year. Maybe we should have evidence so that we don't later disagree about what we had originally agreed upon. Land sales. Land is unique. We learned that we can even have specific performance over land. And usually it's large transactions, very important transactions. Executors. We want people to be careful before they become executors. We're trying to encourage caution for executors and for surety. And with goods, we want to have a standard form. We want to have, again, when we have expensive things sold. By the way, there was $500 doesn't sound like much anymore. There was actually an effort to raise that to $5,000. And it did not get adopted by most of the states. So we still have the goods more than $500. But that actually is sort of an outdated number. I don't know does anyone feel that way as well? Like, look at this, marriage versus $500. Like, that's like getting married versus, whatever. What's an iPad cost these days? So why is an iPad as important as marriage? I think that is a little bit outdated, but we'll take the law as it is, although we should always ask, is the law accomplishing its primary purpose? And you'll recognize that these actually came from that original statute. In 1977, the common law Statute of Frauds categories began. Executors, surety, marriage, land, and year are all in that proclamation in 1677. Although the country that developed it actually repealed it, except for suretyship and land. Interesting that we still hold on to it. Yeah, thoughts?
No, I'm just, because it's very interesting. I mean, land, they said, suretyship, as opposed to an executor.
So, well, we can go into that a little bit. So what is it? So surety means promising to make good on another's promise, guaranteeing another's promise, making a guarantee for another. What about that is so special? What is maybe more special about that? Yeah, Shay.
Well, probably you can say, like, oh, I didn't promise to pay that person's debt, or I didn't do that, but, like, by getting them to sign something, you're holding them accountable. You can actually say this person said that they would pay.
You can actually say that they promised it, right? That person may back out of that promise, right? We also have the most famous article written on this was written in 1941, and I have the title of it. I'll come to it in a minute. In any event, it was called Consideration and Its Forms. And what's very interesting, actually, is the doctrine of consideration in that article. It's a little more theoretical than we need for today. But the aspect of consideration, which may not be present in suretyship. Why would you answer for another's debts? Why would you guarantee their promises? What are you getting from it? May also counsel for why that is a special class of contracts. So, moving on to our practical understanding for today, we might have a contract that falls within multiple classes. Let's look at those again. For example, a contract on consideration of marriage to, if you allow me to marry your daughter, then I will work for you for 3 years, right? I think there was a biblical story about that somewhere. Some of you may recall, right? And they got tricked, right, and had to work was it 7 years? Anyway, in any event, right, that was a contract made upon consideration of marriage, and in fact, it also took more than a year to perform. When you have a contract that falls within multiple of these statutes, it actually has to satisfy both. So just there's going to be a lot of sort of footnotes here. Oh, and by the way, I should have mentioned this at the outset. For those of you who hated studying consideration because it was so unclear, it was such about these, one rule that you apply to a zillion types of facts, you're going to love this because there's plenty of rules here, right? This is rules on rules on rules, and we're going to go over it a few times and put them into practice to try to construct them. But this is a lot of very small, narrow, and detailed rules, very different from our lesson on consideration. So one rule to remember is that if a contract falls within more than one of the statutes, it has to satisfy all of them. So if you're doing statute of frauds analysis, make sure you look at all the categories it might fall under, satisfy all of the separate requirements. So let's go ahead and look at those categories. First, we have the Executor-Administrator category. A contract of an executor or administrator, which is when someone is going to answer. So when you administer an estate, you don't always make yourself liable or responsible, but you can. Right? And we saw this actually came up a lot. In a lot of our cases where a promise was enforced on the basis of promissory restitution, and promissory estoppel, was because somebody died. And the executor was a big fat jerk and didn't want to continue making those payments, right? We saw that in Webb v. McGowan. Remember that one? In that case, McGowan saved Webb's life, and Webb agreed to pay McGowan for the rest of his. But after Webb died, Webb's executor did not want to continue making those payments. This is a little bit more specific. This is when that executor, that big fat jerk who didn't want to pay McGowan, had promised that if the estate doesn't have the money, I'll be responsible personally. And it says a contract for an executor-administrator to answer personally for a duty of his decedent is within the statute of frauds if a similar contract to answer for the duty of a living person would be within the statute of frauds as well. So the executor-administrator is sort of like, think of it as a bonus one, right? It's only a very special situation. We still need to find that it has to be within the statute of frauds generally. So if the person making it, if the now dead person making it would have been subject to the statute of frauds, the promise to make that payment also falls within it. Let me give you an example. S, the executor of D, promises C, a creditor. So D is decedent. I guess we could have had E for executor. So S is executor, as escheator. Sorry, I'll change it to E for next time. S, executor of decedent, promises creditor of decedent that at the time of D's death and in consideration of creditor's promise never to prove his claim against D's estate to personally pay the debt. So maybe the guy owed $1 million, and the executor says, look, if you don't enforce that claim of $1 million against my friend's estate that I'm administering, I'll give you $1,000 today, or I promise to give you $1,000 soon in the future. S's promise is not within the executor provision. On the other hand, S and C enter into a contract in which S promises that if C will assent to S's appointment as administrator, S will pay a debt owing to the debt of C's estate. S's promise is still not within the administrator provision. Suretyship is a little simpler. A contract is not within the statute of frauds as a contract to answer for the duty of another unless the promisee is an obligee of the other's duty. The promisee is a surety for the other, and the promisee knows or has to know reason of the surety relation. So this one's a little simpler because now we have a couple elements that we can work with. So let's take a look at the elements here. It's not within unless we have to answer for the duty of another, right? So we all had this example. So the surety example here is your parents are going to say, if you're going to take out a loan for a car, they don't want to lend it to you because you're a broke law student. And your mom says, tell you what, if my son can't pay, I'll make those payments, right? I'm going to act as surety. I will assure that that debt will be paid. So we're answering for the duty of another. Unless the promisee is an obligee of another's duty, the promiser is a surety for the other, and the promisee, the person who receives that, has to know of the surety relationship. So if, let's say, Derek goes to lease a car, and they say to Derek, okay, sure, cool, you can lease our car. And later I say, Derek, if you fall on hard times, I don't want your car repossessed. I will guarantee those payments. Do we fall under the suretyship provision? What element is missing? The element that's missing is I never talked to the car dealer. That's the promisee. So in this case, Derek goes to the car dealership and offers to lease a car. They agree to lease a car to him, and later I agree to guarantee that promise. The promisee, the person who's issuing the car, doesn't know that I made that suretyship relationship, right? So that's a missing element. On the other hand, the car dealership might say to Derek, I'm not going to lease that car to you. You're a broke law student. I need to lease it to someone who's fabulously wealthy, like a law professor, making buku bucks, right? And so you get me to sign next to you as guarantor. Now at that point, the dealership has reason to know, and we have a suretyship relationship. The marriage provision is that a promise for which all or part of the consideration is either marriage or promise to marry, except in the case of an agreement which consists of mutual promises of two people to marry each other. All right, so marriage does not mean I will marry you and you will marry me. That does not have to be supported in writing. What it means is that if you marry me, I will do X. A promise which all or part of the consideration is either marriage or a promise to marry. If you marry me, I will work for your father for 7 years. Right? That's a promise that needs to be supported in writing. Some examples. In consideration of A's promise to marry B, B orally promises to marry A and to settle a blackacre upon A. B's promise is within the statute of frauds. It's more than just marriage. What's the plus factor? He's going to marry and settle upon blackacre. Example 2. B offers to marry A. To induce A to accept the offer, B orally promises to settle property upon A. If you marry me, I'll make you rich. You wouldn't like me that much, but you might really like this property. A accepts the offer. Both promises to marry and B's promise to make a settlement are within the statute of frauds. It's more than just marriage. I'll marry you if you marry me and give me money. It's not very nice, but it needs to be supported by a signed writing. Okay, so that's the general notion here. Betrothal agreements can also fall within it. A and B mutually promise that each will settle $5,000 on A's daughter when she marries B's son. This is the concept called dowry. These promises are not within the statute of frauds, since the marriage is a condition rather than consideration. So that's sort of interesting. So we learned about conditional gifts, so this is sort of a slight exception to it. Right? In order to get the $5,000, you have to be married. A and B mutually promise that each will settle $5,000 on A's daughter when she marries B's son. This is a fine line distinction, right? This is the difference between Willison's tramp, right, who needed to walk to the store to get the $5,000, get the coat. You need to marry to have the money settled upon you. By the way, I'm going through these quickly because we're going to need to have time for the most important section, the one-year provision. So don't worry too much about all these details. You'll need to know some of this for the future. We're going to just make sure you get out some of these issues. Now, land is special. We know that land is unique, and and land can be enforced by specific performance. And so now we're getting even simpler. Now we're getting to even something we can grasp more easily. A promise to transfer to any person any interest in land is within the statute of frauds. One thing that may trip you up is the notion of transfer. Short-term leases are not transfers in this sense. We're talking about sales of land. Conveyance of land will not count as short-term leases. Leases are not conveyances, and in addition, we have a special exemption. We're going to look at that one twice because the one-year provision is the most tested upon. We're going to spend the most time on it, but it has a connection to the land provision as well. Leases for more than 1 year are exempt from the one-year provision, and oral leases for a year are binding. We'll get back to that when we get back to our most important section. Statutes in most states, except from the land contract and one-year provision, the statute of frauds. All right, we'll see that. So let's talk about that one-year provision. Before we move on, let's briefly review what we learned. All right, we learned that there are five common law categories, of which they are marriage, made and contracts made in consideration thereof need to be evidenced in a signed writing. So the agreement to pay someone because they're going to marry you, right, more than just marriage, I'm going to marry you, you're going to marry me, does not require a signed writing. But if you marry me, then I will provide $5,000, then I will work for your father for 7 years. That needs a signed writing because it is upon consideration of marriage. The marriage is the consideration. And that's why we're kind of mixing the concept of consideration in here. The one-year provision, which we'll talk about, that's the Y and MYLEGS. Land, any contract for the sale of land. Sale of land. We're not looking for a lease of land, but a sale of land. Executors who are answering for a descendant's duty personally. Remember, it's when they're taking a personal obligation. If you are administering someone's estate and you're making your own promise to pay, that needs to be supported with a signed writing. Contracts for goods more than $500, we'll talk about that at the end. It's also relatively important, doesn't come up quite as much. And surety, answering for another's duty, also requires a signed writing. And in addition to that, the promisee has to have reasonable notice. So the one-year provision. This is when there is no possibility of full performance within 1 year. And we're going to slow down here and spend a little more time on this most important, most tested provision of the statute. Let's try to parse the language. Where any promise in a contract cannot be fully performed within a year from the time that the contract was made, all promises in the contract are within the statute of frauds until one party to the contract completes the performance. So let's take a minute and read that. This is important. There's a lot in here. Any promise in the performance cannot be fully performed. So in a whole contract, there can be a number of promises that are rendered. For example, I might promise to pay you $6 in 6 months, $10 in 10 months, $14 in 14 months, and $100 in 100 months. Is that within the statute of frauds? Yes, it is. Yes, it is, because I can't fully perform it. I made 4 separate promises in one contract. I made a promise to pay on this date, on this date, on this date, on this date. Even if those are separate promises, the whole contract is within the statute of frauds until one party completes that performance. Let's look at an illustration. This is our simplest illustration. We'll build from here. A is an insurance company, and it orally promises to insure B's house. It's a pretty common scenario. Promise to insure someone's house for 5 years. And B promises to pay the premium, therefore, within the week. Can this contract be fully performed within a year? What is the meaning of full performance? Can it be fully performed within a year? It doesn't say, will it be, should it be, could it be? Can it be performed? I see a lot of you shaking your heads no. Right, this is why this gets tested upon. Right, this is why we're slowing down. This is one of the trickiest, this is definitely the trickiest part of the statute of frauds. This contract is not within the statute of frauds. This contract is not within the statute of frauds. It could be fully performed. The contract says a promise to insure the house for 5 years. It could be fully performed the next day if the house burns down. There's nothing in this which prevents performance within the year. We'll look at a couple more examples. Here is an example where it is impossible. A orally promises B to sell him 5 crops of potatoes. Where's our Minnesotan? So, right? Sorry, you're like the token Minnesotan here. Do you know anyone who grew potatoes in Minnesota?
Not potatoes.
Not potatoes, anything?
Corn.
Corn?
Peas, yeah.
So how often does a crop of corn grow?
Once a year.
Once a year. Corn grows once a year. Is there any way to make corn grow more often than once a year in the state of Minnesota?
Possibly, yeah.
Oh, well, that wasn't the answer I was hoping for. I don't know if that's actually possible. Let's assume that we are going to not change the ordering of the universe. We're going to have summer, winter, fall, and spring. That will take 1 year. The crops come up in the spring. They're harvested in the summer, and et cetera, et cetera. We have, I suppose, snow for the other 6 months of the year, right?
But what if it doesn't snow?
If it doesn't snow, well, sure, with global warming, there's a chance of multiple corn crops each year, even in Minnesota. Well, at least under this example, it's not possible to have more than 1 crop of corn in Minnesota. So if you promise someone to provide 5 crops of corn or 5 crops of potatoes, right, we cannot have 5 years' worth of potatoes be available for sale within 1 year. Right? So this is a bit different. There's just no situation. So you need to think very carefully about these. In this situation, there is a way. The house could burn down and the insurer could pay tomorrow. It is possible for this contract to be performed. It has to be completely impossible, which I guess this was. Well, you can.
I'll have to call up my grandpa.
Call up and let me know. Is there some way I can make 5 crops of potatoes within 1 year? And if that case, I will have to call the editors of the restatement and tell them to remove this illustration in light of global warming. Yes, Tyler.
I just have a question about the insurance because your house could burn down, but you will still have insurance for 4 and 364 more years, I guess. And then 4 years and 364 more days. So like the contract's still there. Like even though your house burns down and they pay it out, that doesn't end your relationship. Like if your house, if they rebuild it, it burns down again, you're still in the same.
I actually think that it does. I think that if your house burns down, you don't just continue your insurance contract. It would be based on the insurance contract. But has anyone had a claim like?
I just know a friend of mine that like the insurance company then renews the whole contract.
Renews the contract, yeah. Yeah, that contract ends at that point. That contract would end at that point. You would have to have a new contract. And they might not want to insure you. I mean, has anyone here gotten a car accident? I mean, your rates go up, and essentially you are forced to pay a higher rate. If your house keeps burning down, you might have trouble getting fire insurance, right? That contract does not necessarily continue, even though there's an intervening event. We'll see some more. Yes?
I have a quick, so that potato example, that's kind of absurd. I mean, it's an absurd contract. It's still under the statute of frauds. You have to have a signed writing about something that's absurd. Like, it's like you can't possibly do it in 5 years or 1 year because it doesn't exist.
Well, they're not asking it to be done within 1 year. They're saying, the question here is, do we need a signed writing to evidence this contract? Is the contract within the statute of frauds? And it's in the statute of frauds if it cannot, under any situation, be fully performed within 1 year. And this cannot be fully performed within 1 year. We're not saying that it should be.
So if I made a contract to sell you a unicorn
Okay.
Next July, I can't perform that within a year because it doesn't exist.
Well, that would probably be an illusory promise. That's a promise you can't really make, right? That isn't possible. So we aren't talking about what's impossible. Let me try a different example that might resonate with a more modern audience that doesn't grow potatoes, right? So it takes about 700 days to go to Mars, right? And I want to hire you. I'm going to hire you to go colonize Mars. Right? I'm going to hire Madison. I see you shaking your head. You're up for it. You're like, put me in the spaceship. I'm done with law school. I'm going to Mars. Awesome. Right? It takes 700 days to get there. If I'm going to pay you $1,000, I'm going to pay you $1 million. You're never going to get the money, right? 'Cause what are you going to do with it on Mars, right? I'm going to pay you, $1,000 to colonize Mars. Does that have to be evidenced by a signed writing? Is there any way for Madison to colonize Mars within 1 year? So this is your point about being absurd. Under our current understanding of jet propulsion and interstellar travel, no, it takes 700 days to get there, right? It is not physically possible. There's no way that Madison can get to Mars and colonize it within a 1 year period. It cannot be fully performed within 1 year. Now, we can twist this and we can say, and you may want to argue that, maybe it's possible that we invent some new type of interstellar propulsion that propels Madison much more quickly, but that also is not going to happen within 1 year. Most likely that contract will fall within the statute of frauds because it cannot be performed within 1 year. An even clearer example. Does anyone here play piano? Yeah? So you get lessons, you give lessons, Serena? Can I hire you to give me piano lessons at least for our hypothetical here?
Yeah.
All right. So I really need some piano lessons. And I want daily piano lessons. Right? I really am bad. I want to improve quickly. I want daily piano lessons. So I want to get 370 daily piano lessons. Will you sell me 370 daily piano lessons at $50 a lesson?
Absolutely.
Okay. Right, you can use the money. That's pretty good money. So I want 370 daily lessons. Can that be performed within 1 year? Can I have 370 daily lessons within 365 days? Is there any state of the world in which that is possible? No. I was waiting for you guys to shake your heads. No, it's not possible for that to be fully performed. If I hire you to work for a year and 2 days, that cannot be performed within 1 year. If I hire you to give me 370 daily piano lessons, maybe the example for Mars, you can come up with something like, we'll invent jet propulsion, right? And maybe with the potatoes example, we can say, well, I'm going to develop some new kind of potato seed. That's not quite what we're getting at here. We don't necessarily have to go to the bounds of absurdity. But the clearer example then is 370 daily lessons cannot be given within 1 year's time. Did that answer that question? Okay. Now, just the fact that the discharge could be within a year does not excuse the possibility of performance. Right? Now, we're going to make a distinction here between performance and discharge. So, Serena, I'm going to come back to you. I'm sorry for the next twist in this hypothetical, but it is possible. It is possible that between now and then, Serena becomes incapacitated, is unable to give those lessons. Right? No, it's possible, right? You might have a contract to work for a year, and you become unable to do it. Right? I'm not going to go in. When it's me, I do the whole. Anyway, but you become incapacitated and cannot deliver those lessons. Poor Serena, she cannot actually perform on the contract. Now that's possible. Does that mean this contract is not within the statute of frauds because it's possible she will not perform? What do you think, Serena? Did we get out of it? Because it's possible. You could say, I go to enforce the contract against you. It has a signed writing. We have our arguments back and forth. Let's say we don't have a signed writing. You want to enforce this agreement. You're saying that's a great deal, right? Professor Ormer's going to pay me $50 a pop for 370 lessons. We didn't actually write it down. We actually just had this oral agreement. A week later, I try to renege on it, and you say, no, it's an enforceable promise. It's supported by consideration. I say, no, I'm raising the defense that it's under the statute of frauds and there's no signed writing. And now Serena has to then argue it does not require to be under the statute of frauds. It doesn't have to be under the statute of frauds because I could become incapacitated before then. I won't necessarily fully perform. How will the court rule? Who's right? Madison. So I make the argument that this is within the statute of frauds because you cannot provide 370 daily lessons within 365 days. And Serena makes the counter argument that she could become incapacitated before the 365th day, and therefore it's not within the statute of frauds. Who thinks Serena wins and the contract is enforceable without a signed writing? And who thinks the contract requires a signed writing to be enforceable because it's within the statute of frauds? Very good. What's the distinction? The distinction is that Serena is not saying she will fully perform. She's just saying an intervening event might prevent performance. So again, don't get tripped up here, right? The first trip that I mentioned, we have to make sure it's not possible to fully perform. It's not possible to fully perform. But focus now on performance. It's not that the contract could be discharged or excused. The subject matter could be destroyed. I agreed to let you drive my car every day for the next 500 days. And aliens come from outer space and blow the car up. Right? Sure, that could happen, but if we went that way, nothing would fall under this exception. Everything would be except from the statute of frauds. That is not performance under the contract. You didn't get to drive the car. The contract was never performed. The duty might be discharged because it's not my fault the aliens came and blew up my car. We'll deal with that in Chapter 8, whether or not the aliens blowing up my car excuses my performance. That doesn't make the contract without the statute of frauds. John, question?
Would the portion of the contract that was partially performed be upheld and the rest of it abrogated?
So if the person doesn't want to pay, I think your question is, would there be damages?
Right.
Yes. And actually, if people are rendering performance under it, it usually doesn't get challenged in that way. But we'll talk about performance and damages for non-performance in more detail next semester. The short answer, though, is yes. If you got services rendered under a contract, you generally will have to pay for the portion of the services that were rendered to you. Okay. Yes.
I have a quick question. There's an example they talk about in the book where there was an oral contract for construction of, there was 20 buildings, 280 room hotel, and a convention center, and stuff like, there was like more stuff. But, and they ruled that enforceable. I'm just not understanding why.
So part of Thursday's lesson is to go over that problem as a group with the class. So if I can ask you to just hold on to that, because that's part of our lesson. We're going to do Jeff Cole, we're going to go through the problem set, and then we're going to finish up with one more case. So we will talk about that in detail.
Okay.
So thank you. So let's have an illustration of this discharge idea. This gets a little more complicated. A orally promises to work for B, and B promises to employ A for 5 years. This is the example I gave. This is similar to the example of Madison going to colonize Mars, which takes more than a year, and certainly the example where Serena will provide 370 daily lessons. Just to put it in black and white, I employ you to work for me for 5 years, and you will get paid by me for 5 years. These promises are within the statute of frauds. They're within the 1-year provision. They must be evidenced by a signed writing. Though the duties of both parties will be discharged if A dies, the duties cannot be performed within a year. Right? We are looking not for the possibility of the contract not being performed. We need the contract to be fully performed, if the contract cannot be fully performed. The fact that the subject matter of the contract could be destroyed, the fact that people could die or become incapacitated and be unable to perform, does not remove us from the statute of frauds. Discharge is different from performance. Excuse is different from performance. We are looking for performance. On the other hand, we might be able to fully perform if we have a contract of uncertain duration. The illustration from the restatement is the facts being otherwise as stated. Contract for 5 years. I promise to pay you for 5 years, Daniel. You promise to work for me for 5 years. Long-term research assistant gig. Pretty sweet, right? But we both agree that we can terminate that contract at any time within 30 days' notice. Is that a contract within the statute of frauds? You'll work for me for 5 years. I will pay you for 5 years. And either of us can terminate at any time with 30 days' notice. Will that need a signed writing?
Yes.
Can it be fully performed within a year? How long is this contract really? So this is another tricky one, right? How long is that contract really? Is this contract really a contract for 5 years? Yeah, Shay.
Wouldn't you take into account the fact that it could be terminated?
Absolutely. The termination is the key fact that we added here. What does termination do to the duration of this contract? I mean, can you, Daniel, if we make, let me put it in a more human way, right? If I tell you you're going to work for me for 5 years, I'm going to pay you $100 a day, right? And that's that. And there's no other provisions in it. Maybe you might plan around that, right? What might you do? You might take out a lease on a car or a home, right? Because why? Because you would say, well, I'm going to get an income stream for 5 years. And even if Professor Warnberg doesn't want to do it anymore, I can enforce that in court. On the other hand, if I say to you, I'll hire you for 5 years, but I can terminate it at any time, are you going to go out and buy a car? Why not? What changed? Right? If I told you I'll hire you for 5 years, but I can cancel it at any time, what changed?
The ability for it to be canceled at any time, therefore it would fall within the year.
Well, and I mean, forget the statute of frauds for a second. The fact that I can cancel at any time, you're not going to go run out and take a lease. Jacob, yeah.
It's not even a valid contract at that point, it's just a consideration.
Interesting. So I think that, well, you can do the net. So let's say cancel at any time with 5 days notice, right? So you get paid at least 5 days. Right? So that solves that problem. Right? What's the issue? How many payments is Daniel going to receive from me? How many payments is Daniel going to receive from me under the second contract? Who can tell me for sure what that number is? He gets paid bi-weekly. How many bi-weekly payments will he receive? We're all shrugging our shoulders. We don't know. Right? What did I do? By having the net 30 days, the termination clause in there, we made the contract of an uncertain duration. It is now no longer a contract for 5 years. It is a contract for up to 5 years. Does that make sense? You have to look deeper on these problems. What is the contract really saying? We had a contract for 5 years. That was a pretty sweet deal. You could rely on that. You know that you're going to get 26 times 5 biweekly payments. You're going to get 131 payments. Right? You can't tell me you're going to get 131 payments anymore. You might get up to 131 payments, but you might get 4. Right? The contract could be fully performed within a year because we can terminate it at any time. The duration is of an uncertain amount. And we need to have a contract that cannot be fully performed within 1 year. By adding the termination clause, we've made it uncertain. Now, again, with the non-performance, let's say we have the same provision, and this is a little more tricky. Daniel can quit at any time. Now, the restatement says that this actually puts us back within the statute of frauds. What is the difference here? What is the difference between the example where we had a mutual termination clause within 30 days and the notion that Daniel can quit at any time? Yeah, Madison.
His employment from you is like guaranteed for 5 years unless he
That's right. That is the major distinction. His employment is guaranteed for 5 years unless he acts. In fact, you might know this, you can quit a job at any time. Courts will not force you to work, right? Courts will not force you to work. You may have damages if you harmed your employer, if you breached your agreement. That is the key distinction. A contract where an employer and an employee can both terminate any time with 30 days notice, that's a contract of uncertain duration. A contract for 5-year employment where the employee can quit and not perform is very similar to the first example. You can quit, you could die, you could go to Mars, right? In any case, the contract is for 5 years. You cannot fully perform it within 5 years. It's of a certain duration. It just might not be fully performed. So, when does the period begin? Actually, let me pause. That was a lot. This is the most important part. That's why I kind of rushed through the beginning to get to here. This is where you get tested on. This is where it gets tricky. Do we have any questions off the bat? Let's recap real briefly, though, just in case. Right? A contract has to be fully performed within a year. If there's any aspect of it that cannot be fully performed within a year, we're looking for performance, not excuse, not discharge. The contract has to be of a certain duration. Right? So we have to have some time element in it. Now that time element could be I hire you to work for 5 years, or you provide me 370 daily lessons. In the case of the 370 daily lessons, or maybe in the case of 5 crops of potatoes, and potentially in the case of going to colonize Mars, we didn't say take 5 years. We didn't say 700 days travel time. We didn't say give me lessons for a year and a day. We had to reason that out, right? The clear example is hiring for 5 years. But in all of those cases, that contract could not be performed within 5 years. And again, we're looking for that performance, not its discharge or its excuse. So when does that performance, when does that period begin? What does that mean within 5 years? Generally, it means from when the contract is formed, at acceptance. And just another little rule, little footnote, when does it end? It ends at midnight on the anniversary of the day the contract was made. It's just a little quirk. So if you make the contract at 2 p.m. and 2 a.m., doesn't matter. Doesn't matter what type of day the contract is made. The period will run until the midnight on the day, the anniversary of which it is made. So it does not matter what time of day the contract was entered into. I would look out for that as a common red herring, as a distractor, especially in a multiple choice kind of situation, right? The example that says it ends at 2 a.m. No, it ends at midnight. And the policy is that we are disregarding fractions of the day in the way most favorable to the enforceability of a contract. At least that's what has been pronounced. It's just a rule you have to know. But watch out for it because it's one of those tricky ones. So, what is not quite a year? And so, therefore, it does not require signed writing. On December 1st, A and B contract orally for A's employment at a stated salary for a year beginning the following day. The contract is not within the statute because it can be fully rendered before midnight on December 1st, 1967. Right? He's going to finish that performance before midnight. He's going to complete it at that moment. So a contract starting on December 1st can be fully rendered by midnight on December 1st, and therefore is not within the 1-year provision. Remember, he's going to start the following day. So the contract is not within the provision. The midnight rule is just one to remember. Full performance on one side versus the other. If one party performs up front, the contract is not within the statute of frauds, even if the other party's performance is not possible within 1 year. Just another exception. Right, remember what we're doing? We're looking, are we within the statute of frauds? Did we find an exception? Let me show you how this operates. Common fact pattern. A sells and delivers goods to B in return for B's promise to pay $1,000 in 6 months, $1,000 in a year, and $1,000 in 18 months. Can you pay $1,000 in 18 months within a year? No, you cannot. Now, I wrote in here with no prepayment, just to make that clear. Right? There are situations where you could potentially prepay a loan. But here, B's promises are not within the 1-year provision because we're within an exception. It's true, you might say, but Professor Orenberg, I said it was within the 1-year rule because B cannot perform within a year. There's a promise that not can be fully performed, but we have an exception. The exception here is if one party performs up front, right? And so B delivers the goods immediately. So B has fulfilled their obligation. We fall within that exception. Other exceptions. Special exception for leases of land. Leases for terms of less than a year are exempt even if they cannot be performed within 1 year from the making thereof. How does that look? A promises to lease Blackacre to B for 9 months, beginning 9 months from now. I'm sorry for all the math today, but how many months from the making thereof can this promise be completed? We're making it today. The lease begins in 9 months and ends 9 months after. When does the lease end relative to today? 18 months. Right? 18 months. Is 18 months more or less than 1 year? Trick question. No, it's really, 18 months is more than a year, but the statute is exempt because we have an exemption from the statute of fraud. This is a short-term lease. It is a lease for a duration of less than a year. It cannot be performed within 1 year because it is beginning in 9 months from now, but we have a special exemption to the statute of frauds for this one. All right. Now again, just to reiterate for clarity before we go on to what satisfies the statute of frauds, I guess we'll go through the cases on Thursday. The 1 year provision is the most important one to study. The other ones you should know of. They are not tested on in the same level of detail. The 1 year provision is the most technically challenging, and you should know the exceptions to it as well as the rule itself. And you could see, as going through it, it's not intuitive, right? Your classmates and you, I'm sure, were confused by it. We're going to do problems on it, but I recommend that you come back from this, you review your notes, you look at those rules, and you might even try the problems in advance because there's no way to really get it until you practice it. If you practice it, you'll know whether or not you're understanding it or not. All right. So let's go ahead and say we're within the statute of frauds and we don't have an exception. Now we go to step 3. We go to step 3 and we ask, do we have a signed writing? We need one. Do we have it? Why are we asking? We talked about this a bit. We want evidence. We want a caution. We want to channel people to certain forms. Carl Llewellyn reminds us that forms are important. Forms are for legal transactions what a stamp is for a coin. The stamp of the coin relieves us from determining its value. People used to transact in gold. You'd have to first, someone bring some gold to you, right? You'd put it on a scale, you see what it weighed. You have to make sure it didn't have lead in it, that was tricking you up, right? So you know what it was worth. Then the Romans stamped a seal on it, which certified that it was what it claimed to be. Carl Llewellyn suggests that forms work the same way. These formalities relieve the judge of determining what transaction was intended. We can learn more about that here. So by requiring these signed writings, we can force the parties to write standard documents that can help us determine what they meant. When are they signed? What does it mean to be signed? A contract is enforceable if it is evidenced, signed by the party to be charged. The writing has to identify the subject matter, has to indicate that a contract was made, and has to state essential terms. We're going to go a little more into what all this means, but it doesn't have to contain all the terms. So it doesn't have to contain all the terms, just enough to understand what we're working with. It can be informal. It doesn't have to say contract at the top. It doesn't have to even be sent. Now this is a little tricky, and this is the tricky part of the satisfaction clause. It doesn't always have to be sent to the other party. We'll look at some examples there. It can be written on the back of an envelope. It can be a receipt. It can be an entry in your ledger. It can be minutes from a board meeting. It does not have to say contract. It does not have to be sent. But it does have to be signed by the party to be charged. The restatement comment says, where a written offer serves as a memorandum to charge the offeror, communication is essential. Written instructions to an agent to make an offer do not suffice. So it generally does not need to be delivered, but communication of certain offers do. Let's look at the examples. I think they'll make it clear. We can step back to the rule. All right. Here is where a memo that's delivered to a third party satisfies the statute of frauds. And we have to look at who is being charged, who has signed, and who is being charged. A and B enter into an oral contract for the sale of Blackacre. A writes and signs a letter to C, not B. containing an accurate statement of the contract. The letter is a sufficient memorandum, even though it was never mailed and certainly never mailed to B. Why? Because the party to be charged is A. If A is the party to be charged, A's writing of the signed document will count, even if it was not actually sent at all or sent to B. Another example, A writes to B a letter, "Dear B, I will employ you," gives the terms, and signs it. B accepts it orally. A is the party to be charged. A signed a memorandum. The contract can be enforced against A. Could the contract be enforced against B? B only made the promise orally. Probably not, right? That contract probably does not satisfy it as it relates to B. So what are we getting from this? We have to see who is the party to be charged and whether they satisfied the writing requirements. It's not bilateral. And we have that special exception about agents. A writes and signs the letter to his agent C, authorizing C to make the offer stated in illustration 2. C orally makes the offer and B orally accepts it. A's letter is not a sufficient memorandum to charge him. Right, we have that exception. The letter sent to the agent, it was instructions to an agent, will not qualify as a satisfactory signed writing. All right, what does the writing have to say? It has to be comprehensible to the parties, but not necessarily to other people. Right? There's an example in the restatement that says, I will sell you 3 bushels and you will, provide 8 kopecks. Like, I don't have to know what those are, so long as the parties did. Right? We're trying to see, does this evidence that there was a deal? And it needs to identify the land, goods, or other subject matter in a way that the parties understood. It simply has to indicate that the parties reached an agreement, and it has to reasonably identify them. It doesn't have to say a contract. It can be on a napkin, and it can only allude to some of the key terms, right? All we're looking for is evidence that a deal existed. We don't need